Welcome, everyone, to the 2020 Hudson Medal presentation. The Hudson Medal is the Society's highest honor, and it's been awarded since 1959 to a distinguished person of American or other nationality for outstanding contributions to scholarship and achievement in international law. The medal has been conferred on many luminaries in the field, including Rosalind Higgins, Tom Frank, Michael Reisman, Eli Lauterpacht, John Jackson, Bruno Sima, Peter Truboff, and Justice Stephen Breyer. Before presenting the award to this year's recipient, I'd like to thank Paul Reichler, Larry Martin, and the ASIL Law Firm Leadership Circle partner, Foley Hoag LLP, for sponsoring this program, their 7th year of continuous sponsorship. You'll hear from Paul shortly. You'll also be hearing from Professor Edie Brown-Weiss, a beloved past president of Society and the 2010 recipient of the Hudson Medal, who will engage in an informal conversation with Professor Wolfrum following his remarks. But let me begin by thanking the Society's Honors Committee, chaired by Chantal Thomas, with committee members Marcella David, Monica Pinto, Paul Reichler, and Michael Reisman for their excellent work in selecting this year's honorees. And now, on to the medal presentation. Upon the recommendation of the Honors Committee, the Executive Council has selected Professor Rüdiger Wolfrum to receive this year's medal. Professor Wolfrum has been a member of the faculty of Heidelberg University since 1993 and served for nearly 20 years as director of the Max Planck Institute for Comparative Public Law and International Law. In 2005, he became general editor of the Max Planck Encyclopedia of Public International Law, a leading reference work in the field. In 2013, he became managing director of the newly created Max Planck Foundation for International Peace and the Rule of Law. He has authored and edited dozens of scholarly volumes on a wide array of subjects, including legitimacy international law, the law of armed conflict and the use of force, international trade and development, international maritime law, terrorism at sea, and the right to fair trial under international law. Professor Wolfrum also is an eminent international jurist, having served from 1996 to 2017 as a judge of the International Tribunal for the Law of the Sea, and from 2005 to 2009 as the Tribunal's president. From 1990 to 1999, he served on the UN Committee on the Elimination of Racial Discrimination, and from 1993 to 1998, he was the chairman of the Working Group of Legal Experts to the Antarctic Treaty Parties meetings. He's also a leading arbitrator, having served as president of the Tribunal in the Bay of Bengal Maritime Boundary Arbitration and as a member of the Tribunal's Chagos Marine Protected Area Arbitration and the South China Sea Arbitration. I further note that Professor Wolfrum has been a prominent leader of the German bar and served as chair of our colleague society, the German Society of International Law, from 2005 to 2009. Before presenting the medal, I just wanted to read an excerpt from a letter of congratulations from the legal advisor of the German Federal Foreign Office, Ambassador Dr. Christoph Eick. Through your outstanding achievements in public and international law, you've earned great respect both within the international academic community and in the field of legal practice, and have made significant contribution to the further development and increasing prevalence of international law. The list of your activities and achievements could run on for some time. It reflects your outstanding reputation as an expert in international law, which the bestowal of the prestigious Manley O. Hudson Medal underscores and acknowledges. I would like to personally convey to you my sincere congratulations and profound respect for this achievement. And so, for his momentous contributions to international law as a scholar, a judge, and an arbitrator, the American Society of International Law is honored to present the 2020 Manley O. Hudson Medal to Rüdiger Wolfrum. Congratulations, Professor. I'm just sorry that I can't actually hand it to you. I'm very happy to see that you received it.
Here, I can open it if you wish.
Please do.
Mark said I should do that.
Thank you. Congratulations again. So well deserved. Yes, I wish you could hear the clapping of the hundreds.
I can see you clapping. Thank you very much indeed.
Thank you.
Madam President, let me thank you very much, first of all, for handing over this medal to me and for bestowing this fantastic honor on me. I've never expected it, never thought of it. And I take this medal also as a kind of reminder or a responsibility to continue in my work academically and in practice, as you would in the American society expect me to do. Thank you very much again. And I'm really very much appreciate your kind words. And may I take the opportunity to wish you all the best for the presidency of the American Society. Being somewhat associated with the Navy, I would say always have enough water under the keel.
Thank you so much. It's such a privilege to be able to be here with you. And I know we all feel that way. And I'm enormously gratified to hear that your contributions will continue. So thank you. So let me take this moment to introduce a friend and colleague, Paul Reichler. Paul is the co-chair of Foley Hoag's International Litigation and Arbitration Department. Paul's been at the helm of many of the leading landmark cases in the field of public international law, with over 4 decades of experience representing sovereign states before the ICJ, ITLOS, other international tribunals, as well as before U.S. courts. We're very lucky to have Paul as an active member of the Society. And Paul, I want to take a moment to personally thank you for all that you do for the Society, your participation in the Honors Committee, and the sponsorship of this wonderful annual tradition. So Paul, welcome, and over to you.
Well, thank you very much, Catherine. We're very fortunate as a society to have such an outstanding lawyer and individual as our president. So we wish you much water under your keel.
Thank you very much.
I couldn't be happier about the Society's decision to bestow the Manley Hudson Award, its highest honor, on Rüdiger Wolfrum. I can't even imagine a more deserving recipient. In our world, he is the complete package: mind, heart, and soul. His intellect is second to none, as evidenced by his outstanding scholarship spanning virtually every subject of international law. You might even call it encyclopedic, as befits the editor of the Max Planck Encyclopedia of International Law. He was and remains a brilliant and beloved academic, responsible for training and guiding generations of public international lawyers. As a jurist, he has been indispensable, especially when it comes to law of the sea. The international community certainly thinks so. He was elected to ITLOS by the states parties to the 1982 convention a record 3 times, and he was appointed arbitrator in every major Annex 7 case, either by the parties or the president of ITLOS. He has not only left his mark on law of the sea jurisprudence over the last quarter century, he has been its greatest architect. I consider it a great blessing to have had the opportunity to appear before him in 5 different cases, twice at ITLOS and 3 times in arbitrations, including the South China Sea case, where he again demonstrated his customary intellectual rigor, mastery of the law and the evidence, objectivity and fairness, commitment to justice, and strength of character in resisting relentless political pressure. Appearing before Judge Wolfrum was always challenging because he knew the case better than counsel. He asked the most difficult and insightful questions, and he showed no favor to the party that appointed him. But he won you over by his earnestness, his engaging manner, his sense of humor, and his love of intellectual engagement. His happiness in exercising the judicial function was irrepressible. His heart shined through in the twinkle of his eyes and the warmth of his smile. And his soul shined in his great works around the world, especially in some of its most infelicitous places. Not for personal gain, he went to Sudan, South Sudan, Afghanistan, and Iraq in the midst of armed conflict to educate judges, advise on legal and judicial reform, strengthen commitment to the rule of law, and resolve disputes, including the one in Darfur. It took great courage, as well as dedication and personal sacrifice, to carry out these noble missions. At the beginning of these remarks, I called him the complete package. I think all of you would agree that we are honoring a great human being as well as an outstanding international lawyer. I commend ASIL for recognizing the unique and invaluable contributions to law and justice over the course of an immensely productive lifetime made by Rüdiger Wolfrum. Foley Hoag, my law firm, is proud and privileged to host this event in his honor. You will now hear from him directly, and following Judge Wolfrum, our own Professor Edie Brown-Weiss will interview him. Thank you very much.
Thank you very much, Paul, for your very kind words. You have totally exaggerated. I'm blushing, but yes, how should I put it? Nevertheless, I liked it. Thank you very much. I will now speak about, as agreed with Mark, with whom I had contact before, and he had organized everything on the normativity of public international law reconsidered. It is a rather abstract topic, and I must bother you with some abstract parts at the beginning. But as it is my custom, I will fill in some, let me put it, examples to show that I'm not only abstract. I warn you, in some parts, you will certainly want to disagree. That is part of the objective of my brief address. I would like to start with the order of the ICJ of January this year on the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gambia versus Myanmar as a starting point. This order confirms that public international law defines through international treaties, customary international law, general principles, legally binding commitments, and rights of states. As a matter of consequence, tribunals and international courts are deciding on disputes, and these decisions are binding. And as it has been said by one famous member of the American Society, these judgments and awards are quite regularly complied with. I'll come to that. However, is a sole reliance on this, what we call hard law, international treaties, customary international law, general principles, really sufficient to establish and to uphold a sustainable normative order, an order which is adequate for the still growing complexity of international relations? Let us not forget, when I started law school a long time ago, 1964, when then my academic teacher started to speak of public international law, this was not the public international law of today. We had hardly treaties, we had little customary law, and I still remember one of the main examples was the Red Crusader case. Hardly anybody of us knows about it, etc. International law has very much developed. The reasons for this new development is very often referred to as globalization. Eddie has, in her general course, spoken about the complexity, but what are the reasons for that? Sure, it's globalization, but I would add one further element. I accept globalization, but I believe it is now commonly accepted that more and more issues are considered by the international community that they should be regulated in the interest of the international community and not in the interest of particular states or group of states. International law is not anymore a network of bilateral agreements. It is something else. And I believe this has changed it. So substance is more clear, but this is on what I will concentrate on. This has also a procedural element to go with. What do we need to start a regime serving community interests? And how do we uphold such regimes? It's not that we can only start and then believe that's it. Today, the people want a permanent integration into the further development of international law. What do I mean with regimes serving community interests? These are at least those regimes in which most states participate in. And I believe that there are three reasons why we have such regimes. First, the regimes concerned is meant to govern common spaces like high seas, deep seabed, etc., outer space. That's quite evident. Second, the objective of the regime in question can only be achieved if at least a majority of states participates. And that is more complex. For there you have to deal with a free rider principle. And just to give you a catchwork, the Montreal Protocol solved this problem. Third, there are those regimes which are based upon a common value judgment. And this is covering all human rights regimes, broadly speaking. The most recently established examples for regimes serving community interests are the Global Compact for Safe, Orderly, and Regular Migration and the undertaking to eradicate poverty. I'm referring to the Millennium Development Goal. These are new complex regimes which can only work if at least a significant majority of states will participate in it. I believe these are also based on value judgments. When I speak about common interest, this is by no means something very new. It is actually the contrary, it's very old. Already Francisco Suarez, 16th century, referred to common interests, and he said that the conservation of justice and peace between states in order to preserve the common good of mankind. This sounds today rather modern. But why have we forgotten about the theories or the teachings of Suarez? That is, in the 19th and the early 20th century, international law was dominated by the belief on individual state sovereignty, which was, so to speak, the focus. I could quote others besides Suarez, but given the time limits, I would not do so. It is a logical consequence that regimes serving community interests must be established in a procedure which is open for the participation of all. This is standard practice. Most of the regimes considered as serving community interests were initiated by resolutions or declarations of the UN General Assembly, or declarations, resolutions, agendas, and whatever you name it, by multilateral conferences in which all states were able to participate. And if you want to see today a model how such a regime is being developed, you can look into what is being done on BBNJ, the biological resources beyond national jurisdiction. We are in the full process after the UN General Assembly has declared the principles which should be governing this new regime. These regimes, and here I may face some criticism, form a particular part of public international law. I would not say this is all public international law. We have two different parts. The international normative order in respect of regimes serving community interests gives much more weight to soft law than traditional international law. Soft law, I understand soft law as instruments which are either through their wording or explicitly declare that they are not legally binding, but binding, although they are meant to influence the policies and actions of states, and they are formulated as norms. These are the ingredients I see in soft law I'm going to talk about. If you look at a typical example to that extent is a global compact of migration, which I've already mentioned. On the basis of an empirical review, you can see that these soft law instruments have a very differentiated impact upon the formation of international normative order in general, on the establishment of these regimes in particular. Soft law instruments have started the establishment of regimes serving community interests in the past and will continue to do so. Second, the principles and doctrines defined in these soft law instruments were guiding the negotiations and the establishment of the regime in question. I will come with examples to that extent. Third, although these principles and doctrines were incorporated in the regimes, they still have a life of their own. They remain relevant. And very often they go beyond of the regime they have created. Alternatively, a soft law instrument may be implemented, substituting a whole international agreement. And a further alternative may be that a soft law instrument prescribes an elaborated network of rights and obligations. In spite of stating that it is non-legally binding, it is expected to be implemented. As I said, all these regimes were negotiated and drafted with the full participation of the international community, and that is different from the traditional international conference with the participation of NGOs or other elements of the civil society. Let me give you three examples. First, the Outer Space Treaty is just the reproduction of a couple of General Assembly resolutions. That this regime is meant to serve the interests of the international community is well established. The whole corpus of law on international, on the environment, and let's not forget, I remind you, I started 1964. The teachers at that period would never speak about international environmental law. It didn't exist. It depends when you say it started. But the first international agreements, or declarations, I should rather say, were the Stockholm Conference of 1972. And it took place only with the Rio Conference of 1992, with the Rio Declaration on environment and development. It's very important. That's not only on environment, but in environment and development. The Agenda 21, the pronouncements of the UN Conference on Sustainable Development, and finally, the outcome document, The Future We Want. I consider this as the Rio system. You may say this is a little bit broadly phrased, but I believe that fits. The principles directives developed in the various declarations have not only been relevant for the interpretation and application of the treaties coming out of this complex, but they have far-reaching implications in other areas. An example to that extent is Principle 15 of the Rio Declaration, the so-called precautionary principle. The soft law, which evolved from the Rio process, provides the underlying philosophy for that treaty system and the various treaties, including new ones, and still the ones which are going to come. What I'm describing is nothing very new. The whole human rights system is based upon the Universal Declaration on Human Rights. Why am I told that this is switching off? Doesn't matter. And you could also refer in this context to the Helsinki Declaration of Principles. Other soft law instruments which have had a significant impact and are different in some form is the FAO Code of Conduct on Sustainable Fisheries. This code of conduct is in fact replacing an international agreement which has not been adopted. Still, although it is meant not to be legal binding, FAO requests information why it is being implemented, or much more important, why it is not. Could you hear? I don't know what we should now do. I will continue to speak. Most challenging in this respect are soft law instruments which have been adopted instead of a treaty, and where such a decision has been made consciously. In other words, why has it been done, and what is the meaning of that? This is the case in the Future We Want outcome document. And here you have some explanation. It says, we, the heads of state and governments and high-level representatives, having met at Rio de Janeiro with, and I emphasize, the full participation of civil society. You will take it from what I've said so far, that soft law is very much interwoven with hard law. And let me stop a second before we have a picture. Here we are. Did you hear me? Good. Okay. I couldn't see you, but I could.
Yes, we heard you.
Good. Perfect. The question is, and this is a question which is on your mind, I hope. How do courts and tribunals deal with these instruments? Are they enforceable? And how are they enforceable? And what are the mechanisms? Do they lead to a weakening of international law as such? I say no. But before I come to that, what is the action of international courts and tribunals so far on that? For example, the precautionary principle has been quoted and referred to and even being used by the law of the Sea Tribunal in the Southern Bluefin tuna case. At the same time, or nearly at the same time, I should say, when the ICJ in the pulp mill case was not ready and willing to use the precautionary principle. And however, if you read what Itlos said, and I confess it's a provisional measure case, it is only 2 sentences. They are dogmatically everything but convincing. We say this is customary international law. Where's practice? Where's opinio juris? Nothing said about that. And this is a problem with other international courts and tribunals when they deal with these principles. Even the ICJ, when referring to the Declaration on Friendly Relations, they say this is customary international law. Shortcut, and in my view, not convincing. But let me come now to the enforcement. First of all, the FAO Code on Responsible Fisheries is enforced via the reporting system. States have to report, and in that respect, the FAO borrows from a system of the human rights regimes, where reporting is a major form of enforcement. That means we have an enforcement system, and certainly a good one, but I come back to this code of conduct in another context. The Global Compact for Migration states in paragraph 7, and I quote, "The Global Compact presents a non-legally binding cooperation framework that builds on commitments agreed upon by member states in the New York Declaration for Refugees and Migrants." Taste that. Dogmatically, it doesn't work. Let's be honest. for the declaration is also soft law. Therefore, soft law and soft law doesn't fit. But we have to accept that in the framework of this soft law instrument, we have legal commitments. They are, so to speak, the frame for these legal commitments. These legal commitments, these are unilateral acts, actually, can be fully enforced. And there, through these commitments, the whole compact can be enforced. And you now may find this a bit daring. The Paris Agreement is not much different. The Paris Agreement, if you look at the agreement on climate change, it doesn't contain much apart from obligations of conduct. And even they're rather weak. But in the moment a state like Germany makes a commitment to reach a certain target in whatsoever year, then this is hard law. And here again, we have this framework, which is soft law, but it's like within a cherry. You have something hard inside. The extreme example to that extent, which I have not included in my speech, since Eddie has written so much about it, is the Arctic Treaty System. The Arctic Treaty System is a system of soft law instruments. Within that system, we have 2 hard law treaties and something very new, an arrangement between several other institutions. Therefore, here again, the framework, the political framework, is not hard law, but within that, we have hard law. Still, I have to go through the question, bring up the question still, what is the function of international tribunals? Let me give you a case. Let's go back to the Fisheries Code of Conduct. Under the law of the Sea Convention, the fisheries regime has to be implemented with due diligence. It's a due diligence obligation for flag states and coastal states. Let's assume the flag state, I take any flag state, is not really living up to this code of conduct, being a member of FAO or not being a member of FAO. My view is that that state is not exercising due diligence. What I want to say is the following. These open norms are filled by soft law, and through this can come under the jurisdiction of international courts and tribunals. Apart from that, these soft law instruments will be implemented more via what is more modern than it used to be in international environmental law, namely the more friendly compliance system, compliance by assistance rather than pushing the carrot, not so much the stick. Let me conclude. In my view, the international normative order has to be understood being a composite entity of soft law and hard law. And soft law is reinforcing hard law due to the fact that it brings modern ideas, and secondly, that it is much more universal than hard law. Thank you very much for your attention.
Thank you very much for that presentation, Professor Wolfrum. I want to congratulate you as a good friend and a longtime colleague on the medal and on your presentation, your important presentation on the common interest and the role of soft law for a sustainable normative order. In the minutes that are remaining, I would like to ask you a few quick questions, and I know that some of them you covered actually. But one question that really relates to this, you've referred to non-legal enforcement of regimes that rely on soft law. because enforcement doesn't rely at all on judicial means. Could you perhaps elaborate how you get compliance then, very briefly, and whether this approach is as effective as relying on judicial means?
Yes. First, we have different forms of soft law. Remember the three various forms. They are either directives or freestanding or in the combination of hard law. Let's start with the last case. There is a soft law instrument such as the Universal Declaration of Human Rights. Today it is customary international law. But before that, this is being enforced together with the International Covenant on Civil and Political Rights. There's so much interwoven, and the Universal Declaration will help the interpretation and in particular the implementation of the covenants or the new, more recent agreements, such the agreements on the rights of the child, etc. The freestanding soft law, what I referred to is the Code of Conduct of FAO, is enforced by reporting. This is all we have in human rights, and therefore this is not less, but not more effective than that. But the most important element is that we have to accept that hard law consists of what I call blanket norms, norms which are very open for interpretation. And here soft law brings in means of interpretation. For example, due diligence. What does it mean? If Paul Reichler would argue on the basis of due diligence, he would have a wonderful bouquet of flowers to be presented to the court in question. And we, the judges, would be able to pick the one or the other. Now, if he would argue a fisheries case, then in this case, we would look into the code of conduct. These are the flowers which we believe belong into the due diligence, and give the due diligence this broad obligation contours and therefore provide for legal safety and make it easier to have due diligence obligations to be implemented. I hope that answers part of your question.
No, it does. And I wish we had time to carry this debate on much further, because I know that the advisory opinion of ITLOS very much focused on the issue of due diligence and developed it. And I know that you had a role there. I want to turn to your role as a judge on the law of the Sea Tribunal, just to push you a little bit more and look at the advisory opinion of the Seabed Disputes Chamber and the role that soft law played there in further, if it did play a role, in further developing the law related to state responsibility, and to ask you how useful this was. Or we could refer to the Bay of Bengal case, in which you wrote a separate opinion that also looked at the role of soft law potentially there. So if you could just very briefly do that, because I want to have time to ask you about your future plans, because I know everybody is really interested in your future plans.
Yes. Speaking about the advisory opinion of the Seabed Disputes Chamber, here is a due diligence which we used, but frankly speaking, I would not be totally satisfied as we did it. It's self-critical, I must confess. The precautionary approach is an integral part of the general obligation of due diligence, paragraph 131 in the advisory opinion. That's correct. That's a way out. What was this missing? Why is it so? And I believe here there is a missing link. We could have done better. And if you could look into, I believe it was a separate opinion of Judge Peck in the Fisheries advisory opinion, he said we should look into soft law, we should seek guidance from soft law, but again, the dogmatic is missing. And that is the reason why I wanted to bring this up, to find the missing link in our dogmatic. I could also say that the ICJ has referred to very often the Resolution 2625, the famous declaration, or the one on aggression, They have been used in the Nicaragua case, in the pulp mill case, there was something. And particularly interesting in this respect is the advisory opinion of the war in Palestine of the ICJ. But here again, they use these soft law instruments without really integrating them. Also, the armed activities in the territory of Congo, there is a reference, to put it that way.
Okay, well, thank you. Thank you.
Let me say the ICJ was in this respect much more forthcoming than it was.
Thank you for elaborating on those issues for us. In the time that remains, may I turn your attention to your future plans? I think we are both interested in that. You've mentioned a couple of things to me. And so let me just ask you about the first one, which is, I gather you may be interested in the relationship between environmental law and human rights.
Certainly so. This is one issue. And human rights play a greater role. For example, the right to water has been developed from the treaty body of the Covenant on Economic, Social, and Cultural Rights, and now is being used to enforce the water law. And here you have this situation of an individualization of environmental law, which is enforcing implementation. That's an interesting development. That is one issue. We have referred to law of the sea and human rights too. This is another issue which is perhaps of interest. But my main interest will remain on environmental law, and also in the comparison of the enforcement system on these both systems, which are going to be more and more integrated. You can see it easily when you come to liability for environmental damage. My other interest, don't forget I'm a German. We have to be, as German public lawyer, I have to do also national law or constitutional law. And I'm very much engaged, I'm speaking the foundation on constitutional law. And here sitting a team, we write or try to write a draft constitution for the Sudan. You know, there was a revolution. President al-Bashir has been ousted. We were at that moment in Khartoum. I have been in Khartoum while seeing a revolution. That's quite an experience. I didn't expect that to happen. We were even on the place where all the demonstrators were meeting in the night. It was an interesting experience. The problem is, however, we have to be very careful. We cannot say that there is a universal approach towards constitutions. Every constitution reflects the history, the cultural legacy of a given country. No constitution is alike. And to believe we could take over the American Constitution, although by all means it's a very successful constitution, is not working. And therefore, we are in a dialogue. We try to develop considerations for a new constitution, which hopefully will serve that country longer than the, I believe, 6 constitutions they had so far since the 60s. And none of it lasted longer than 2 or 3 years. That is one issue which will occupy me, at least apart from my academic writing, very much.
Could I press you to elaborate on that a bit? Are there differences upon which the constitutions of different countries are based? Or are there sort of a common element that one can rely upon?
There are very
element that one can rely upon.
Yes, there are some common elements. Rule of law, at least if you take it generally, it means for all of them more or less the same. But that's all. That's not so much. First of all, rule of law means that we have to follow the rules of the law. But who puts up the law? Only Parliament or the executive or in combination? In the Sudan, we have the practice so far that the president can issue decrees which are law and are enforced like parliamentary law. Actually, the parliament has very little legislative power. But therefore, if you shift the lawmaking more into the parliament, then you have a different rule of law. Then it means rule of law means to follow the rules set by the parliament. And in the future Sudan, this will be not only a central parliament, it will be also a parliament within the states of Sudan. Whereas if you go into a system as it was before, then it's the rule which was accepted. And therefore, that the constitution is the supreme law of the land, for us, self-evident, not necessarily in the Sudan. Al-Bashir has disregarded that main principle. These are problems. The other problems come from cultural backgrounds, from religious issues. Is the Sharia an inspiration of law? Is it the basis of law? Or should it be banned from the Constitution? These are issues which we are going to decide in the next meeting with our colleagues, 30 to 40 in Khartoum.
I think you and your colleagues there have your work cut out for you. It's very important work, and we look forward to following that. In the few remaining minutes that we have, I want to turn back then to look at your speech on the common interest and the role of soft law in developing a sustainable normative order, and give you a chance to say what soft law ought to do in the further development of law. You've touched on that, but I know that you wrote a separate opinion in the context of equity in the Bay of Bengal decision. And I would like to give you a chance to sort of elaborate on that now that you are looking back on your many years, more than 20 years as a judge on the law of the Sea Tribunal.
This was my separate opinion. I had two issues to focus on, and you referred to the second one. Namely, in Article 74 and 83 of the Law of the Sea Convention, it speaks about the delimitation of maritime areas. If you look into these two provisions, they're identical. Nothing is much said. Only it's been said that the result, either by negotiation or by arbitration or adjudication, must be equitable. What is equitable? And here, the courts, particularly the ICJ, have developed a system which is a so-called three-step system. The fullest developed in the Black Sea case. And I believe we so far have misunderstood these articles. These are, for me, a mandate to the courts to act as legislators. They should set the rules how to establish what is equitable. They have legislative power. And in that respect, and that's why I coined the word, this is something which is for us binding, and acquis judiciaire, it is justice made law. For you from common law, this is much easier to accept than for me coming from Roman law. But I believe 74 and 83 has to be understood in that way. And this gives a particular relevance to the jurisprudence of ICJ, ITLOS, and arbitration.
Thank you very much, Professor Wolfrum. I think we have heard a really very, very interesting presentation today on especially the role of soft law in the development of a sustainable normative order. I am very grateful to you. I found it very interesting, as I know all of our people did, and I'm sure many of us have many questions. And if we were to meet again in 10 years, we could then ask ourselves, where are we now in terms of the role of such soft law and soft law-based regimes in advancing public international law and a sustainable normative order. So with that, I would like to thank you. And I'd like to turn it back to our distinguished president.
Thank you very much. What a terrific presentation, Professor, and thank you to both of our Hudson Medal winners for that really remarkable dialogue that points us to perhaps some places in the future where we can think about the development of public international law. So really thank you to both of you. Thank you, Paul, as always, for being with us and joining us for this special presentation. And let me thank the audience. Again, we have a record number of registrants in this meeting, so I'm very pleased that we have a lot of people who are sharing with us their thoughts and are having the benefit of these presentations. So please tune in this afternoon at 4:30 for the ceremony that's recognizing all of the year's honors and award recipients. And of course, we'll have the lecture later this afternoon for Grotius. So thank you again. Thank you, Professor, and congratulations. I hope that medal goes somewhere special.
Thank you very much indeed. I appreciate that, and I very much enjoyed our small discourse, and I would like to continue on that.
Absolutely.
Wonderful.
Take care, everyone.
Paul.